You don't have to be represented to take a claim to the tribunals, and if you're only owed a couple of days holiday pay, you probably don't even need one. But the tribunals are part of our legal system. They're presided over by judges who are not there to hear your story and work out what laws may have been broken or what compensation they could award you. You have to say when you put your claim in the type of claim it is, what laws you say have been broken, and how you've calculated your schedule of loss. For example, if you believe that you were discriminated against but didn't put this on your claim form, even if the tribunal agrees with you, they cannot award you compensation. That's one of the good reasons to get yourself a good employment law specialist. If your claim includes a loss of earnings, the tribunal could award you all of your losses plus another 26 weeks future loss, and sometimes even more. Or your ex-employer could succeed in arguing about mitigation, contribution, and a host of other legal stuff that could get your compensation reduced dramatically. That's another good reason for being represented by experts who know how to win your case and fight your corner. Here is a brief guide on how the compensation is worked out at Tribunal. The number of things to take into account is huge, and the amount awarded largely depends on individual circumstances. Other contributing factors would be the limitations. Compensation for discrimination or dismissal related to health and safety, for example, is unlimited, although there are guidelines which the judge will take into account. If you're claiming only for unfair dismissal, the award is made up of two parts. Firstly, the basic award, which is worked out on your age, time of service, and your weekly wage. Second is the compensation award, and this includes things like a loss of earnings. The second part is set to a limit which is reviewed every year. In some circumstances, the tribunal could order your ex-employer to pay you all of the back pay that you lost out on when you were dismissed and to give you back your job. If the employer fails to do this, the employment tribunal can make additional awards. Other breaches of employment law and wrongfully dismissal have an award limit of £25,000. The process can become even more complicated if you have claimed job seekers allowance or income support since the breach of contract. In many cases, people might not realise that compensation is only intended to replace a loss of earnings, in other words, to put you back in the position you would have been in if you'd not lost your job. There are, however, some exceptions. In discrimination cases, you can get an award for hurt feelings, and there can also be an additional award if you were a whistleblower. How quickly you manage to find another job after you've left or were dismissed can also affect your compensation. Reputable and experienced employment law specialists such as Your Employment Matters could help you with your claim and help you through the compensation minefield. For more information, contact youremploymentmatters.co.uk today.